Good afternoon. This is Diane, DNF Properties, DRE number 007444960. Today is April 13th, 2023, and I just left a seminar presented by Gov Hutchinson. He's from our legal department at the California Association of Realtors, and he comes to our board twice a year and introduces new forms or talks about laws that we need to be aware of. There's a few of them that he did mention today, and a lot of them are related to landlord-tenant law, which is getting more and more complicated every day. We are in California in a state of emergency because of the flooding. We left the COVID state of emergency ended. Now we are in one in reference to the emergency for the flooding that we had the past few months. 51 out of 58 counties in California have that emergency status. So what does that mean? That means that you can't increase your rents more than 10%, even if you're a single family home. There is a protection, a rental increase protection in California, and some cities have them a little bit stricter than California, which you have to be aware of if you're renting. Most of them do not apply to single family homes or condominiums. However, in this case, because we are in a state of emergency, you do need to comply with that law and not increase your tenants more than 10%. Actually, properties that are 3+ units or 15 years or older do have to comply with the Rental Protection Act. So you can only go up 5% plus inflation. So right now it's around 10%. The numbers will come out again with the new inflation numbers pretty soon. But right now you can't go more than 10%. If you are a single family home, you can, but you still need to be careful. You just don't want to be caught with discrimination. And also to protect you from the rental increases so that you can exempt yourself out of that Tenant Protection Act, you need to make sure that you give your tenants a form that exempts you from that. If you do not give your tenants that form, either at the time of the lease or if they've been there for a long time, you do have to give them that form, you will be subject to the same rules as apartments and 3+ units. So it's really important to give your tenants that form. If you use me as a leasing agent, and when I use my California Association of Realtor forms, that form is automatically included in the lease agreement. But just to let you know, if you've had tenants for a while, you may want to reach out to me and ask me about that form. So there are a lot of landlord tenants laws. It's getting more and more complicated. You got to be really careful when you have tenants and you're renting them out. If you evict your tenants for whatever reason, and they find or maybe you increase their rent and then they leave, and then later on you rent the house for a cheaper price. Your tenants find out, they can claim it's a discrimination. You kicked them out because of discrimination. So you got to be really, really careful. And if you're not careful with your eviction notices and all the notices that you need to give your tenants, if it comes to that, my advice is to hire an attorney that specializes in eviction. I have a very, very good paralegal that does evictions. She's very good at it. She's been doing it for years. So if you ever need any references, I can give you her number. And I have a few other attorneys that specialize in the eviction as well, if you do need that. If you purchase a property using an FHA, VA, or conforming loan, there is a law saying that you need to give your tenants, when you evict them, if for non-payment of rent, you have to give them a 3-day notice. And usually if you're not using a government-sponsored loan, after 3 days they have to leave. But if you did finance that house, purchase that house with one of those type of loans, and you have a tenant, you have to give them a 3-day notice. And if they haven't paid it in 3 days, then you have to wait another 27 days for a total of 30 days in order to start eviction. Again, the laws are really complicated, and I really advise that you speak to someone who knows those laws. One thing too that he mentioned in the class is that because we've had a lot of rains and a lot of damage of property here in California recently, if something happens to a property while you're in escrow, the seller has a responsibility to repair that. And he said even if the seller rents back and something happens before the seller leaves, even though they're technically renting, that the seller still needs to fix that property. Um, uh, there are many laws that are passed every year, and only about 20 to 30 of those laws are real estate related. So of the 1,000 that the governor signs every year, there's not that many, but there are some that could be really critical to real estate. There is a new law that a tenant has a right to use a reusable tenant screening report. So instead of paying for a new credit report every time they get an application in for a rental property, they can go to the special screening agency who does one report, and then they can use that for all applications. A landlord does not have to accept that report, but it saves people money, so it might be a good idea if you're used to that report to do that. There's also another law. If there's a domestic violence in the home, if there's a domestic violence between tenants, the person that is being abused can demand that the landlord evict the other or the bad tenant. So, and then you'll have to go through those steps and evict that tenant. They'll have to prove that they've been domestically abused by a police report or a restraining order, but you have to comply with that if you have that situation in your rental. There are laws that making it easier to build an ADU in your backyard. There are also laws making it easier to reconfigure your home from like if you have a 2-bedroom and you want to convert it to a 3-bedroom, so you're just moving walls inside the house, you're really not adding more square footage. So they have laws to make it easier for people to do that kind of configuration. Let's see. Can't discriminate against Section 8. So if you're renting your home, if you're renting your piece of property and you have a lot of tenants that come in with Section 8, you cannot say, no, I won't take you because you have Section 8. So you cannot discriminate against source of income. So you have to take those Section 8 tenants. You can have guidelines that you give everybody with specifics that you want for a tenant, like minimum FICO scores, minimum income, minimum debt to income ratio. You can have those guidelines. You have to give those guidelines to everybody. And you should accept the first tenant, whether they're Section 8 or not, with the guidelines that you have on your form. But that's the easiest way to protect you against any discrimination lawsuits. Let's see if there's anything else here. Oh, there is, as far as our purchase agreement goes, a lot of times buyers make an offer on a property that has a tenant in it, or maybe they have the sellers in it, but they have other people living in the house that are not on title. Those people can remain and cause problems after escrow if they don't leave. So there's a new form that we have to protect the sellers, the buyers, to protect the buyers of the people that live in the house, and we'll ask the seller to fill that form out and tell us who lives in the house. And the form also says that all people have to vacate at close of escrow. There's also a few new disclosure forms in reference to solar. So if you have solar on your property as a seller, you want to make sure you give that form to your buyers so that they know exactly the terms of that lease, if it's rented, if it's owned, and all the particulars on that. And there's a new form too about non-contingent offers. We are having low inventory again, and we are seeing increased multiple offers again and prices over asking. So when a buyer comes in with a non-contingent offer, we have an advisory form so that that buyer is well aware of what they're getting into and the risks involved with a non-contingent offer. It protects everybody and it makes the buyer real aware of what is going on there. The other day I did have another seminar that I went to, and it was in reference to HOA properties. Anything that's condominium, planned unit development, even single family houses in a planned unit development are subject to HOA rules and laws. 80% of all the new construction that's happening now and in the future are going to be in these community interest developments, common interest developments, where there is a lot of common property and then your own property, and you have to follow those HOA rules. So a lot of deficiencies have been happening on the HOA's documents. So sometimes older buildings have deferred maintenance and the HOA has not collected enough money, and you end up seeing deficiencies either the seller or buyer has to pay for it. Sometimes the buyer comes in and finds out later, maybe 2 months later, that there's a deficiency like decks. Right now is a big thing where decks have to be inspected, and they're finding a lot of dry rot on decks. And then the buyers come in and have to pay $20,000 or $30,000 on an assessment for those decks. So it's really important to make sure that you really understand those HOA documents. An accountant can review them. There's a lot of financials in there. There's a lot of stuff that maybe an accountant would understand. I do have someone who specializes in reviewing those documents, and she also specializes in getting the proper documents for the buyer and the seller from the HOA company so that we have everything disclosed. Very important just to be aware of these things, because when you buy a piece of property, you want to know exactly what you're purchasing. That is all for now. I know it's a little long, but I just wanted to review this with you and let you know that the market is really hot again for sellers. If you are selling your property, it's a really good time to put it on the market. Not every single area is getting crazy multiple offer bids, but if you have a well-priced, well-marketed, repaired, staged, beautiful piece of property, and it's priced correctly to the market, you're probably going to have it sold quickly. So if you have any questions, if you want to buy, if you want to sell or lease a piece of property, you can call me at 408-221-6602. That's my cell. Or 408-270-9776, my office. I'd be happy to help you or answer any of your questions that you may have real estate related, or if you need vendors or attorneys or accountants, I have those sources for you. Thank you so much for listening. Have a wonderful day, and we'll see you next time.